Yesterday, around 4:47 in the afternoon, Donald, no one from Trump's legal staff, set out. Not at all comparable deliberate reluctance of lawyers meeting prior to making a declaration. The immobilized quietness of individuals who have just viewed their whole plan fall simultaneously. Because 18 hours while the majority of Americans were asleep, nation's highest court handed down a decisive decision so irrefutable that it nullified all safeguards that Trump has been constructing for duration of 3 years. All claims for immunity, all the case for executive privilege, each and every strategy his attorneys used to postpone the case throughout over 40 civil lawsuits and 42 criminal cases, case closed. Throughout the 247-year American background of the Constitution, the highest no judge has ever revoked a former executive director of defense attorneys in every way. Both Nixon and Clinton were absolutely nobody, and this is something that ought to scare this very second. All three justices who were personally nominated by Trump to that court, the judges tasked with act as a barrier between him and potential danger, they decided to vote for his ultimate protection completely in his favor, seeking to get a handle on what recently broke, not in sound bites from cable news, however, the rules of law that are going to, in the event that a sitting president visits inmate. Please subscribe to my channel just now, since the next thing I'm going to reveal is not being addressed in any other context. Time has only just begun to tick, and Trump is given 14 days to reply to an inquiry of his is deemed impossible by attorneys to answer. Your attention has been drawn to the ruling regarding in the media, the one that all is responsible for covering. There is a public version of that. 63 pages of legalese that the press were granted access by the Supreme Court to upload it to their website so that anybody could get it now. However, an additional matter exists, something that hardly anybody is discussing due to the fact that its existence is profoundly unknown. A 47-page sealed appendix is available, private viewing only for lawyers, about the case and the justices who will be reviewing it of it. And as per an insider's report with having firsthand experience with its contents, one paragraph in the accompanying appendix includes damning proof that it would prompt swift legal requests for 3 distinct grand trials by jury. Allow me to provide you with the second file that you are unfamiliar with. During the early versions of the Supreme Court's ruling, a fragrance was detected, the Honorable Clarence. The 32-page document that Thomas had authored justification for unchecked presidential immunity. Samuel Alito, a justice, is on board. Judicial nominee Brett Kavanaugh was swaying on the path to become one of them. It is our knowledge that, due to the fact that draft opinions are in-house prior to their finalization, Supreme Court precedent dictates that procedure. Yet, a turning point was reached when the 8th of January, acknowledged by the court-sensitive information briefing from the the courts. All eyes were on the Trump case's effects on national security outside of the public eye for 2 hours. Furthermore, while after the conclusion of the briefing, Thomas rescinded his slightly off, Alito failed to submit his in agreement flipped by Kavanaugh in full detail. The verdict came down to found in favor 9-0 on a per fairness which encompasses all 3 of Trump made the decision that went against him. For what reason was at that meeting, we are clueless. It is kept secret. However, regardless supporting documentation that the U.S. demonstrated that the judges were persuasive, not nearly enough to overcome all ideological preferences, allegiances to political parties, regardless of any worry regarding set the standard. Many were persuaded by it, those who hold conservative views on the Supreme. The judge ruled that Trump's protection required greater, more harmful than the substitute, and now, for the third paper, every single thing. In the depths of page 34 of the ruling is the due date for filing, Donald Trump, the deadline for submitting an official reply. However, the attorneys eye the opportunity to converse with those who have engaging in constitutional litigation for years. They all state the identical thing. It won't be able to answer because the proof he who wants to defend themselves would have to give in, where he could be implicated in addition to 3 further lawsuits that are still out of court. In order to grasp justification for the extreme anxiety felt by Trump's legal team manner at the moment, you must comprehend that resulted from 5 disastrous errors that, at the present time, these 5 choices looked prudent back then, but turned out to be true construction of a trap that merely closed abruptly. First and foremost error, using immunity too extensively. Whenever that rejected by the D.C. Circuit Court of Appeals regarding Trump's claim of full immunity, the legal team he was working with had a choice. Get over it, go on, and concentrate to alternative defenses. They opted to file urgently, submitting an application with the highest court in the land. It was believed that most conservative group would permit a hearing, purchase them sometime, perhaps rule to their advantage. What they received, utter stillness. Over the course of 11 months, the higher. The judge made no ruling. Additionally, the attorneys representing Trump perceived the lack of sound as a sign of contemplation as the court's justices meticulously considered difficult constitutional concerns. They were incorrect. Consensus was reached in that hush. Coming into being, no one was arguing before the court regarding Trump's protection. Their status was developing a stance so firm that the president-elect might stake a claim about Trump asserted his assertion. Second blunder, the dilemma of the witness. Do you recall the time when Mark Meadows was granted partial protection from the deadline for testimony as January 6th committee? It was a major development, yet it indeed wasn't a nuclear weapon. One can find additional witness, an individual who is legally affiliated with Trump Group, is in the dark, has worked with attorneys representing the accused. When it comes to legal documents, this name is used exclusively in a coded manner. Executive Assistant number 1. This person was available to take calls. Donald Trump is currently assertions were never made. Shown at presidential campaign sessions according to Trump's safety, rather than reversing outcomes. And the witness has recently turned in 917 pages of current remarks to the relevant authorities' defendants with the date and signature time-stamped, each and every discussion, guidance, every instance of anxiety as the violence intensified on January 6th. I had thirdly, failing to consider connection to Georgia, even though zeroed down on the federal charges against Jack Charging Smith in the District of Columbia. Fani, the district attorney for Fulton County Willis, was constructing an alternative, the whole scope of a racketeering case involving, in accordance with the identical factual data, identical eyewitnesses, identical timetable. I present to you the trick that Trump's associates failed to notice. Head of state, a court's decision is applicable to more than charges brought by the federal government. There is a clear found in subsection 3 of section 4 that immunity testing is just as applicable to judicial processes within the state, which implies that as soon as the decision was made public, all defensive immunity Trump intended to immediately lost all use in Georgia. The Fani Willis's trial date is hoped that April 15th will work, 11 weeks beginning today. More so than in federal instances, pardons cannot be granted for state convictions by all-time head of state. The fourth error is the funds. An attorney for Trump has been devoted so much energy to exposing criminals that it would seem that the civil cases, the judgment of $8.3 million in the slander lawsuit involving Eugene Carroll, the 454 decision in the case of the New York State attorney case involving the general's fraud. The two of them decisions have been postponed until appeals mainly grounded in assertions of privileges and immunity from prosecution. The recent decision by the Supreme Court has removed these claims. Seizing assets can start within a month. After then, Trump's actions right now, everyone on his legal team is rushing by way of 3 potential exit strategies. I will demonstrate each one and explain why each mess results from choosing just one path. Runaway starting point, submit a request for an emergency stay inquiry with a certain Supreme Court equitable treatment. The following is a typical legal action to take when pausing a decision as you draft an extensive appeal. The president's attorneys have previously done this. Their case was, together with the Chief Justice, the judicial conservatism, the inclined to have a compassionate view of justice. Within 4 hours, Alto turned down the request. It took 4 hours. In order to provide some background, submissions typically take several days. At times, it can take weeks for a judge to think about. After reading the record, Allo remarked no very quickly. What follows is it informs us. There is a seal around supporting evidence, the confidential appendix I prior to this. The contents of those even Alto was persuaded by the 47 pages that it's not only that Trump claims immunity small and unimportant. Evasion strategy 2, call upon the political challenge the established doctrine. Okay, so this is a position stating that tribunals ought not to resolve issues that are fundamentally political, that there are inquiries that fall under the legislative and executive departments, not the court system. Bush versus Gore made use of a version of this reasoning from the year 2000. Team Trump is thinking about suing, accusing a sitting president of wrongdoing is an issue of politics that the courts are unable to preside over. However, the issue lies here that this was already expected by the Supreme Court. Debate and annihilated it before it even started. Page 78 of the decision states that viewpoint directly tackles the theory and practice of politics, and it describes to the last intricacy as to why it fails to, and prosecutions for the crime of past and present presidents alike. The language is crystal clear, a door that is closing in on you as you continue the opposing camp. Number of the escape route 3, the nuclear choice. On top of that, this is where the situation becomes extremely risky for American Republic. Anonymous sources with knowledge of we are, says Trump's legal team, contemplating a challenge to the authority of the court, contending the court went above and beyond its Article 3, the authority to issue this ruling. No, this is not some far-flung notion. Legal insanity is what this represents. Absence of qualified will have their name included in a document in which the validity of the Supreme Court's paramount power. But this is where the terrifying element. 3 attorneys have, prior to leaving Trump's team, instead of submitting this motion this week. Just one of them was a member of the Federalist Party chairperson, a staunch conservative who has advocated on behalf of Republicans throughout 3 decades. Now, let me show you exactly what is in the Supreme Court ruling that has legal experts calling it the most consequential opinion on presidential power in 50 years. I am going to walk you through 5 specific passages that change everything. Passage number 1, the immunity rejection. On page 23, the court writes, and I am quoting directly, no person in the United States, regardless of office held or previously held, stands above the reach of criminal law when private acts are alleged. Now, that might sound like standard legal boilerplate, but look at what comes next. The court adds a parenthetical. This includes sitting and former presidents. They did not need to include that phrase. The sentence works without it, but they put it in deliberately because they are not just ruling on Trump's case. They are establishing precedent for every president who comes after. No future chief executive can ever claim what Trump tried to claim. The Supreme Court just removed that tool from the presidential toolkit permanently. Passage number 2, the evidence standard. Normally, in criminal prosecutions, the government must prove beyond a reasonable doubt that the defendant intended to break the law. But buried in footnote 19 on page 41, the court does something remarkable. They adopt what is called the reckless disregard standard for cases involving former presidents and official acts. In plain English, this means prosecutors do not need to prove Trump knew he was breaking the law. They only need to prove he ignored obvious warnings that his conduct was illegal. And we have 17 documented instances of White House counsel Pat Cipollone explicitly warning Trump that his post-election schemes violated federal law. 17 warnings in writing with witnesses, in a passage number 3, the executive privilege exception. For decades, conversations between a president and his closest advisors have been protected by executive privilege. Presidents need candid advice, the theory goes, so those conversations must remain confidential even after they leave office. The Supreme Court just created a massive exception to that rule. Page 56 states that argue that the power to sign executive orders does not involve conversations that took place in support of illegal endeavors. The crime fraud exception is the legal term, and the client's attorney has used it for some time, advantage for a long time. After a simple carried it over to the executive branch's privilege. For the layperson, what does this imply? It means that Pat Sipp is the only witness who can attest to every single thing. Undertaking testimony is within Mark Meadows' capabilities regarding all matters. Michael, the VP Pence, is qualified to testify on any and all discussion he held with Trump regarding refusing to accept the results of the election, discussions that took place at the Oval Room at the presidential mansion on First Class Flight 1, each and every one of it, having no longer shielded. The fourth passage, the pitfall of document production. I present here the unnoticed footnote. Note to the reader, 48 on page 112. This pertains to the written work, Necessities for Manufacturing. A ruling is rendered by the court on the occasion that an ex-president asserts specific documents fall under the purview of head of state. He needs to make those records to the businesses and corporation examination of the camera. Thus, Trump is obligated to deliver the paperwork to the judge shall personally review them. But this is a tricky situation. Assuming those records reveal sanctioned behavior, the right to disqualify them from being used as evidence. Now come with me as I demonstrate the results when you schedule every one of these trial dates on a planned calendar. Seeing them sprawled out like that, visually striking, something that chilling materializes. This goes beyond multiple cases. A collision has occurred. Program that aims to develop compounding disaster in the eyes of the law. On the 7th of February, that is 14 days after the Supreme Court's decision overturned, creation of documents due date, Trump needs to make a decision about generate the confidential papers that the judge is ordering or refusing to obey a direct Supreme Court order. If his output with them, they end up being proof in a number of cases. It would be a crime if he declines, disdain, and possibly obstructing equitable treatment. 2 weeks before the deadline, February 15th, immediately following that, the district attorney for Fulton County, the appointment of a hearing by Fani Willis to choose a date for the RICO trial in Georgia, based following the decision of the Supreme Court to remove arguments based on immunity, experts in the field of law anticipate. Ask for a trial to be held right away. The April has been her preferred date. The 15th, that will be in 12 weeks. The 4th of March, half a month in advance. Mr. Tanya, the judge, when Chutkan's trial originally was scheduled for Nation's election interference lawsuit, and she put it off until after the upcoming challenging the immunity, such pleas merely was destroyed. Allegedly, she is planning to reconsider rescheduling the trial for either the beginning or the end of April-March at a hearing that is scheduled to take place in May the 4th, April 15th, 7 weeks from now. The Empire State, the decision regarding civil fraud is finalized and feasible to implement. Legal counsel Letitia seizing assets is something James is able to start. The process, Trump is the topic at hand. 40 Wall Street, commercial tower spaces, the estate of Seven Springs, financial records. An order for $454 million is being seized on April 1st after a 10-week period of rest. On trial for secret papers in the Sunshine State, Alan Cannon, the judge, has been dragging out this case while utilizing defense based on arguments of immunity. The latest Supreme Court decision undermines all only justification she offered for the delay. If the 11th Circuit decided the case, now tell her to go ahead right away. On April 15th, 12 weeks will pass. Trial in Guam starts now. 18 accused individuals, 41 allegations, conspiracy to commit racketeering. This is Stan's tallest. Federal charges, none possibility of a pardon from the federal government. Plus, that turns this into a downward spiral, having one evidence that is presented in a trial on the upcoming trial. Georgia witness evidence, D.C. transcripts included. Records from D.C. appear in the proceedings in New York. Federal verdicts impact the jury pools in each state. Every instance justifies every other instance more powerful. There isn't a way out. It is you are unable to resolve crimes. I am unable to rid them of their immunity. It is you are unable to grant pardons for state convictions. Now allow me to do something that very few people would suffice for this story's coverage. Permit me to present the strongest argument for Trump's protective measure. Why? Because if I can't deal with their most compelling case, consequently, I am not conducting an analysis here. Situation, nothing more than a cheerleader. The primary argument, This falls under the realm of politics criminal prosecution. The time seems to be right. Extremely practical. These instances speeding up at the same time in a year of the election when Trump is in Republican candidate in the lead, with no prior president of the United States has ever have faced criminal charges. It was everything sensations like never before because it is never before seen. When it comes to the look of the influence of politics is difficult to disregard. This is the point where the argument falls apart. Nixon, Richard, would be facing charges. He was pardoned by Gerald Ford in particular to evade legal action. During his presidency, Bill Clinton was accused of lying under oath. However, the norm in order to cover up a private matter is distinct from stirring up a mob to halt handing over authority. The first of its kind that is not being prosecuted, it holds the key to conduct. There is audio of Trump asking the Secretary of State of Georgia to identify 1180 votes. Our records show that there was a fake elector scheme in 7 states. We indulge in a violent 2-hour session at the Trump Observed while watching television, the Capitol, still adamant about continuing. The why the president has evaded prosecution in the past is that not a single president has Trump's actions. Second point of contention, the Trump faces bias from the Supreme Court. His appointing 3 justices just cast their votes. In his place, the conservative news outlets asserting their dominance in the deep state, their way into the highest court in the land. After that, could you please clarify this? That is, why was Samuel Alito and conservative justice sitting in the court reject Trump's candidacy? With what grounds did the judge rule that decide in favor of Trump regarding the presidency, access to the records from 2020? For what reasons do the ruling panel cite Federalist documents and decisions made by Antonin Scalia on a regular basis? Nothing biases the court. There is a mountain of evidence and the legislation is without ambiguity. The third point is that this is militarization of the judicial system. Courts are being utilized by Democrats to eradicate an adversary in politics prior to election. Allow me to put that theory to the test if it's weaponization. Trump should never have appointed judges deny his right to a trial by jury claims. Republicans' decision to public servants such as Brad Raffensperger and could Gabriel Sterling testify in his defense? What was the rationale behind his own AG, Bill Barr? You're denying the existence of election fraud. Here are 3 potential outcomes this turns out to be for the United States. Reason being, the following 3 months will does more than decide Trump's destiny. It decides the character of our nation. Accountability is the key to the future. Trump faces charges in numerous jurisdictions. Proof is offered in grass field. Evidence is presented to juries by examiners who are sworn in. If there is proof provides conclusive evidence of guilt, he gets a conviction. In that case, he is not guilty. In any case, the system is functional, exactly as planned. This establishes a standard that is without ambiguity. The law applies to everyone. Presidents, not super rich people, not heads of state from any political faction. How much? Is social unrest and temporary political instability division. In the long run, it's beneficial. Trustworthiness of the institution. The Democratic demonstrates its ability to entangle influential persons in charge. The second one coming up, responsibility falls flat. The judicial system receives intimidated. Victims face threats to not give their testimony. Judges step down when they're feeling the heat. The jury receives did not perform. Dismissal of cases occurs when finer points. In his departure, Trump does not on the brink of a decision, the previous one. This set is absolutely devastating. The story is all of the presidents to be that you are able to plagiarize while holding public office and confront no repercussions provided you uphold clout in politics while retaining your support ready to act. Law and order transform into choice for the wealthy and powerful. Following that, leader who accompanies them, an individual, more intelligent and self-controlled than Trump, finds out the best way to take advantage of area of vulnerability. Thirdly, in the future, the bone break. Varying courts and various authorities arrive at various conclusions. State judges who lean red reject such instances as persecution due to political bias. Blue state courts find guilty. the federal judiciary divisive on the basis of ideology. Finally, we reach in a scenario where the president is at the same time found not guilty according to the court you inquire with. The mayhem this causes is immense. Which do we have legitimate courts? Decisions made by will, we proceed as planned. The law is no longer impartial arbitrator and turns into nothing more than political tool. Additionally, in cases where the legal system is unable to settle disagreements, remove obstacles, vacuum cleaner. This trend has been observed in different nations. This is not the final chapter without incident. The events that take place in the following 2 days. As of Monday, Trump's deputy, the group is required to submit their reply to the Supreme Court ruling or admit in writing they are unable to do. This past Tuesday, Fani Willis is in Atlanta for a press conference. Be on the lookout for the summons to appear in court. Judge Chutkan has set a hearing for Wednesday, proceeding in the nation's capital, the possibility of her resetting the federal trial scheduled for April. Plus, this is for which I am keeping vigil. Signal frequency, that is, a speaker from the White House counsel on a public scale. Sip in solitude, Eric Hirschman. The attorneys in this case never address the ongoing situations unless they are life-threatening. If interviews for television begin for them, it signifies that they have been freed from attorney-client privilege restrictions as the dam is on the verge of failing. Signal number 2, Mike Pence's testimony. Schedule. If he is called to testify within 30 days, prosecutors are moving at maximum speed. Signal number 3, Republican senators going quiet. When even Lindsey Graham stops defending Trump on television, when the most loyal allies suddenly have no comment, that is when you know the end is near. This is the most consequential legal story of our generation unfolding in real time. Subscribe right now and turn on notifications because the next 90 days will move faster than cable news can process. Share this video with anyone who still thinks this is normal politics. It is not. Comment below. Do you think Trump will comply with the Supreme Court ruling or defy it? I will be back in 48 hours with an update on what is happening behind the scenes in Georgia. Something is developing that changes everything. The walls are not closing in anymore. They have closed. The only question now is whether there is a way.